Jerry, if you could, first, thank you for joining us.
Absolutely.
Introduce yourself again for the few that don't know you, because I think you're becoming a household name. You're a reference point for Hoss Spencer in the Daily Progress, multiple rodeos here on the I Love CVille show. Introduce yourself to the viewers and listeners, please.
Okay. First, thank you again for having me back. I'll start with the same disclaimer, and that is I am not counsel to any of the plaintiffs in the lawsuit we're going to be talking about, or any other lawsuit that's going on here in town. I'm just a commentator like you, and I'm studying this stuff, from the perspective of a lawyer. But I think there are things that you don't have to be a lawyer to understand, and that is this whole YIMBY movement with all the insanely radical zoning ordinances is a nationwide thing. I mean, it started in Arlington, it's now in Charlottesville, but everybody in Virginia is going to be facing this, and as well as other parts of the country, so they'd better be ready for it.
And Charlottesville's in the eye of the storm.
It is in the eye of the storm, but there are two really basic facts about what's happened in Virginia so far. Fact number one is that the Arlington zoning ordinance, the new zoning ordinance that had all these radical changes in it that tried to get rid of single-family zoning and so forth, as it sits right now, it is void. And in Charlottesville, exactly the same story. The ordinance is void, even though it may be the 22nd of August before we have a final order. The judge mentioned yesterday that he has that, and he wondered aloud why it took so long for him to get it. I can explain that because I know what the reason was for that. But the only reason that those ordinances are void is because brave citizens, residents of those two locations, had the courage to stand up and sue and manage to get enough people concerned about it to raise the money to pay attorneys to fight it. I mean, attorneys generally don't do things for their health. I'm doing this not so much for my health, but just out of for my conscience. But it costs money to do that, and so they've shown a great deal of courage. So the city council, and one of the reasons I think they're going to need the courage going forward, is the attitude that the city council has expressed to their own citizens through their lawyers, both the outside counsel, Gentry Locke, and through the city's lawyers. And the first bad attitude is the attitude that Gentry Locke and the city took, which is, well, just because they filed a complaint, we don't need to file an answer, do we? Well, you've got a law school up the road here, and you're going to have first-year students are going to know the answer to that question here in about 2 weeks. That's like the first thing in civil procedure, and so that shouldn't be a shock to the city's lawyers. As I said, whether they're in-house or whether they're outside, you do have to file a timely answer. And as I said on the show last time, if you don't do that, the judge has discretion to enter a default judgment, and you lose. And in this case, the city lost, and the plaintiffs won, and that's why the ordinance is void.
So let me jump in here. So the city has been without stable counsel in place. It's been a turnstile with the city attorney. As a result, they outsourced the responsibilities to a third-party law firm, Gentry Locke. Gentry Locke is not cheap. They are specialists in this zoning world. They missed a filing deadline. They came hat in hand on bended knee, mea culpa, basically begging the judge for forgiveness. The judge, this happened, yesterday?
Yes.
The judge yesterday heard the ask for I'm sorry from Gentry Locke and the city, and now we have some new developments and maybe movement on a calendar that I hope Gentry Locke has. In fact, we may have a calendar on set here or not. Gentry Locke, if you're watching this program, you need to get an iPhone and put it in your calendar with a reminder 24 hours in advance. Get a print calendar with a Sharpie all around the date, Gentry Locke, because your first mistake was about as amateur hours you could possibly find.
Well, and the argument in court yesterday, as part of that on the knees there, and by the way, they had probably the three most expensive partners in the firm at the council table.
How much are we talking in an hour? Ballpark?
At least, I think that one of them bills at $720.
Okay.
I think is her $720, $750, somewhere in there.
Okay.
So that's a lot of money. I presume the city is paying them. Again, I wouldn't expect them to do this for their health either, especially when their reputation is on the line. But to have three partners there opposite the one, I'm not sure if she's a junior partner or an associate on behalf of the plaintiffs, was something that struck me. Part of their argument, though, which is the new twist, is they argued that it'd be too harsh for the judge to find them in default and award judgment to the plaintiffs because they, the defendants, they, the city, say, we will win on the merits. And the judge said, well, the only thing that I've left in the case to go to trial is the question of your preparation of a traffic study that you submitted to VDOT, and so they would have some idea what all this density is going to do to highways around the state. And he didn't come out and say it, but I think it's pretty clear that that's one of the counts that the plaintiffs have relied on very heavily, because there are no weasel words with that. Either you did a traffic study or you didn't. And the judge said to them, all right, convince me that you have any prayer of winning on that, and I'll think about it. That's the only thing that's hanging up the final result of this. But I guarantee if there were a traffic study, I'd have it here in my hand.
Right.
We would know it. And they didn't do that, and they're not going to win on that. And that sure as heck isn't a reason to excuse them for missing the filing deadline.
So we know that there was no traffic study done. Then why was any kind of perceived grace offered by the judge? Any kind of extended deadline offered by the judge to find whatever this traffic study is or is not?
I don't know. I mean, he'd have to explain that. All I know is that he cited a case that neither side mentioned in their pleadings, and I read them both, or in their oral argument yesterday. So the judge kind of has his own agenda going there, and I guess he just wants to satisfy himself that he's not squelching a valid defense, but that's really mixing up the merits and the procedural aspects of the motion. So I don't know how that's going to change anything. I think the bottom line is that by the 22nd, there will be a default judgment entered, and that will be it. And the city, can go forward with their threat to just readopt the ordinance.
Okay.
And so I expect that's how. If I had to make a prediction, that's what's going to happen.
Okay. A follow-up question, and I'm trying to reiterate this from your standpoint. Did the city sufficiently coordinate planning with VDOT? From your standpoint, yes or no, and why?
No.
Okay.
As far as I know,
because no study.
They didn't do one.
There we go.
And again,
And that's where we're at now.
Right.
That's the decision here.
I think so. I think that's where it's going to come out.
Yeah.
But, you have things like other counts relied on things like, the city should give reasonable consideration to things. When you have a weasel word like that you're dealing with, and a lot of room, for a judge who wants it to come out one way or the other to say, well, reasonable is as reasonable does. But this provision in the state statute is really explicit. And like I said, either I got it here in my hand or I don't. So I don't know how the city is going to claim in the next few days that they had this study at the time the city council adopted the ordinance. I mean, we're talking close to 2 years ago when that happened. So I don't know what that's about, but I don't think it's going to make any difference. It certainly shouldn't make any difference. The problem is that the city attorney thinks that the council is not limited by state statutes. And I've been a Virginia attorney for 46 years. He's been a Virginia attorney for 46 days. And because of that, when the plaintiff, and this explains why the judge didn't have in hand a final order, a proposed order, is because the plaintiffs offered a fig leaf to the city. They offered a compromise to them and said, okay, we'll agree to a really heavy-duty, higher-density zoning code. Just not this. Not what you've passed here, because this is radical. It's just so far out there. We're not going to agree to that, and we will, keep the lawsuit going. We will go ahead and ask the judge to enter the default judgment, and if you will agree to scale it back, then we will not ask him to enter the final order. And the response that John Maddox wrote back to them from the city, if you don't mind, I don't want to be reading stuff
Please,
to
go
your
ahead,
audience,
please.
but I think his words and a letter that he sent to the plaintiff's lawyer on July 22nd tell you everything you need to know about the attitude that the city is taking with respect to this litigation. He wrote, your clients simply disagree with the city council and the voters who elected them about what type of zoning the city should have. These are not legal disputes. They're political grievances, and the proper venue for addressing them is not in the courtroom, but in the ballot box. Well, I'm sorry, but if there is an issue about compliance with a state statute, that belongs in the courtroom. That is not something that you're going to be able to deal with or get a fair hearing on as an opponent of this. But he says, well, not to worry. because we will afford your clients, the plaintiffs in this case, the opportunity to pursue their preferred zoning changes through the public process with a fair hearing before the Planning Commission and Council and a full and fair opportunity to make their case in the proper forum. Minor detail, the same day, the Court of Appeals of Virginia issued a decision that said all the provisions that say you get a public hearing in cases like this are nothing but a check-the-box exercise. You have no right to be heard. You don't have any right to be listened to. Basically, all you have a right to is to go and check the box. And so that's a completely empty promise, and I can't believe that there's a city attorney who could honestly say that to these plaintiffs.
You have 2 Albemarle County supervisors watching the program, 2 city councilors watching the program, a Commonwealth's attorney watching the program, a couple of Virginia delegates watching the program, and a boatload of realtors and developers watching the program. I know why the realtors and developers are watching the program, because this directly is impacting their business.
And if the city had accepted the compromise, their shovels would be in the ground right now. I mean, they're not just messing with these plaintiffs and the homeowners, they're messing with the developers.
They're messing with the economy.
They are.
They're messing with the economy. One of the plaintiffs...
Over an ideology.
Yeah, right. Exactly. Over perceived weakness, over perception. Roy Van Dorn, one of the plaintiffs, emailed me within the last 25 hours. And we'll get Roy Van Dorn on the program, one of the plaintiffs. And he, in his email, said that the plaintiffs are still feeling the pain from the back of their hand of the city. And he's talking about the fact that the city is not negotiating in good faith with the plaintiffs, who are literally trying to offer an the plaintiffs have the edge here. The plaintiffs have the negotiating leverage. The plaintiffs, if you looked at how everything was playing out right now, are heading to winner's circle. But they were willing to work with the city and kind of meet in the middle. And what you're saying, what the plaintiffs are saying, what we're hearing is the city wants nothing to do with that.
This situation is not of the plaintiffs' making. I mean, they stood up and said, City Council, guess what? Contrary to the legal advice you seem to be getting now, state statutes apply to you too. You're not above the law when it comes to that, and you do have to comply with it, and we're going to make you comply with it unless we can work something out. But the advice I have, because you may remember when I was here last time,
I love the prop.
I brought this for the new city attorney, and because this is a Gregorian calendar, as I mentioned before, one of my favorite things, since I was a child, I've always paid a lot of attention to the calendar. Good way to keep track as you get old. But in any case, I even circled the scheduled trial date of 22 June of 2026. And now, if I'm right about the result we're going to get on the 22nd, on the 22nd of August, I'm scratching this out. There's not going to be any trial in June of 2026. There's not going to be a trial. There might be a trial in June of 2027, but it might be 2028. And even if it is, by the time the appeals are over with,
absolute mess.
You're going to be 2029 probably. Yeah. And that is absolutely no way to run a railroad. That's no way to run a city, but it is not the plaintiff's fault. It is entirely because of the recalcitrance on the part of the city and because they are so ideologically committed to this. And to the extent that, talk about toxicity, and if all the back and forth seem toxic, the recent development is that a New York Times columnist who claims to be very tight with members of the city council...
Jamel Bowie, we talked about that last week.
Jamel Bowie posted, when he was asked, he had posted that one of the plaintiffs' houses should be torn down for having the temerity to sue the city over this. Tear his house down, he proposed.
He's got nearly 700,000 followers on the Blue Sky app.
Yeah, and one of them asked him, "You're not really serious, are you?" And he said, "This is totally a serious suggestion. I have even talked to my friends on city council about it because it is absolutely, definitely serious."
I mean, it's just crazy.
Well, it's reprehensible, but it's also a violation of law. And that's the other thing. If you'll let me, I'm going to read something that the city attorney should be thinking about a lot. I certainly, if I were in his shoes, I'd be thinking about this and trying to protect my council members because there's something in federal statute. We're not talking about Judge Worrell. We're talking about the Western District of Virginia. There's something in federal statute at 42 United States Code section 1983. It comes up in the press a lot because there's a lot of litigation over it. I've personally never done any litigation in this area, but there are plenty of people, including a lot of young plaintiffs' lawyers who will work on a contingent fee basis who would read this out loud, and I think the city attorney should be reading this out loud to the city councilors, because here's what it says. It's under the caption, Civil Action for Deprivation of Rights. Every person who, under color of ordinance, subjects or causes to be subjected any citizen to the deprivation of any rights secured by the Constitution shall be liable to the party injured in an action at law for redress. That is to say, if any city councilor so much as told Bowie that, yeah, that's a good idea, we should be working on that, they have violated this provision and they are civilly liable, and probably making the city civilly liable as well. And I hope that the city attorney has verified that that was not true, that didn't happen, that Jamel Bowie is lying when he says he's been talking to city councilors about this. Even if he is lying, there's another problem, and it's one for him more than it is for the city council members, because Section 1985 and that same title in the code, and I know we're getting down in the weeds here.
No, please do.
Yeah, but this is something that everybody should know about, and that is in 1985, there's a provision against obstructing justice, intimidating a party, a witness, or a juror. In this situation, and I'm not going to repeat his name, but the person whose house supposedly should be torn down is a plaintiff. He's a party in this litigation, and he is also a witness. So one should take into account the provisions in that code section. It says, if two or more persons conspire to deter by force, intimidation, or threat any party or witness in any court from attending such court or from testifying to any matter pending therein, or to injure such party or witness in his person or property on account of his having so attended or testified, or if two or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating the due course of justice with intent to deny any citizen the equal protection of the laws, or to injure him or his property for attempting to enforce the right of any person to the equal protection of the laws. So that's one that Jamel may have violated right there, as long as there was somebody else that he was tangoing with. So if there's any truth at all into what he posted to his 600, 800,000...
Nearly 700,000 followers on Blue Sky.
Yeah, well, he's telling them one thing, and if it's true, he's just indicted himself in doing that.
And if it's not true, he's completely called into question his journalistic integrity. A man who makes his living with his words. He's either on the side of breaking the law or on the side of having no journalistic integrity.
Well, this is the New York Times.
It is the New York Times. I mean, I'm shocking that the New York Times even allows this kind of behavior.